behalf of the appellant and cross appellee, I guess is the right way to say it, Ocean Bank. This is a dispute between...
Well, this is entirely clear. I mean, there's no question. I mean, why don't you guys just sit down? You know exactly what would happen.
Like, you know what, Judge?
We know exactly what would happen. I of course, am kidding.
Okay. Actually, I thought you were serious because it seems fairly straightforward to me, but
yes.
This is a priorities dispute between Ocean Bank and the condominium.
Tell me what money are we disputing? Sure. What was the source of the money? Who was the money supposed to be paid to at any time? And where is the money now?
Easy. The amount of money involved is $18,200. That amount arises from the amount of rents that were generated and collected after Ocean Bank served its demand for the rents.
Well, let's talk about the demand. Because that is the sticking point. Well, the demand is it a condition precedent to file a separate written demand for the interim rents and then a rejection or refusal to pay those rents by the renter? Is that a condition precedent to filing a claim that includes a claim for rent?
The answer is no, for a number of reasons.
Tell me why, under Ginsburg, your answer is no.
Could you tell me what money is involved?
I can't.
This money is not in the registry, is it?
It is not. It is held by the association.
It's already been paid
to the association.
By whom?
By the tenant.
But has the association remitted back to you the allocation in the order under review?
No.
Okay. So it's still held as the court directed an apportionment that they would be able to hold maintenance fees and put the rest of it back.
Right. It wasn't exact. That wasn't exactly the apportionment. The apportionment, which obviously we have a huge problem with because it's our rent collateral, in essence gave the association approximately $16,700 out of the $18,000 in rent.
But the rent, you say it's collateral, but it's collateral out for the mortgage, isn't it?
It's collateral. And
the mortgage has been foreclosed, hasn't it?
Yes, and the answer is no.
And you are now the owner of this condo, correct?
No.
Why not?
Well, let me answer all of your questions. First of all, there was a separate assignment of rent.
We know that.
The rents are collateral for the repayment of the debt, not for the mortgage. Just like we have real property as collateral, we have rents as collateral. And we're entitled to pursue both until we're repaid. Yes, we finished the foreclosure. Ocean Bank purchased the property. It's been since resold at a huge loss to the bank, and we still have $40,000 or $50,000 of debt.
Well, you were the owner before you sold it. Did you secure the property at the sale? Were you the purchaser at the sale of your mortgage foreclosure?
Yes.
So you were the owner of the condo unit, and then you sold it to somebody else.
That's correct. Judge, we have.
When you were the owner of the condo unit, you had to pay the fees, didn't you? You had to pay the assessments and everything as a condo.
Yes, that's a separate issue. But
why is it a separate issue?
Because that's not what was litigated here at all.
Why? Maybe it should have been.
Okay, but we have to pay the fees once we take title.
Yes, okay.
And
before that, before you took title, the association had foreclosed its lien, and it was the condo, and it purchased at that sale, and it was a member of its own association, correct?
That's true.
So, obviously it didn't owe money to itself.
No, I think there's a statutory exception for that particular circumstance.
No, as a matter of fact, the exception doesn't apply because they are the owner, and the exception doesn't apply.
What I was saying is I think there's an exception when the association owns in its own association, it doesn't have to pay the fee.
Oh, of course not. Yeah. I mean, it's silly.
Okay, so...
But here's my concern, and that we're talking about different time frames with different circumstances.
Yes. Right.
The initial time frame and circumstance is that the renter defaults on the mortgage and the note,
The owner.
or the owner.
Correct.
And
The renter was paying, correct? The tenant never defaulted on the rent.
That's true.
Right.
Even after the foreclosure judgment, the tenant continued to pay, and that's
Still
why
there, and they're still
that's
paying?
Yes. No, the tenant's gone now, we said.
Oh, wow, okay.
So
But
the owner defaults.
Right,
So that's the initial step.
right.
Under the case law, at least under Ginsburg, under Howard, it appears that as soon as that happens, because you do have a recorded ability, the fact is that you can go after the rent. It would appear to me that the first thing the bank had to do was demand the rent then from the defaulter in writing, and the defaulter has to refuse to pay the rent. You then file your foreclosure action seeking, the rent as well as the foreclosure based upon the default. But I don't see where any written demand and any refusal to pay was ever occurred. That's the first step. Then the second step, and you can answer them all. The second step, as I see it, is now the association forecloses on the property. They now become the new owner. If you want the payment of rent from the new owner, it would appear to me you would have to again file a written demand for the interim rent from the new owner. That was never done. In fact, it appears that the only complaint that was filed was against the original owner and requesting, the interim rent from the original owner. So take those two steps, and then you get to the third step when you now become the owner of the property. So,
I think this is what they call a compound question in the law court.
But they're all attached
Compound
to this,
and complex.
but it's all attached to the same premise that I have a concern about, which is the filing of this written demand and then the refusal to pay the rent after the demand.
Okay, let's start with that. A written demand is in the complaint. There's a clear demand in the complaint, and it's not just to the owner. It's to the tenant, and it's to the association. The language is very clear that
The tenant has never done anything wrong. The tenant is always paid.
I understand, but
you're saying that the tenant should have paid you instead of its landlord.
right, but we're not really blaming the tenant here.
It's not a
Obviously,
blame, it's a question of whether you are entitled to the money or the association.
we are, because we have a priority security interest in these rents. This is the equivalent of a second mortgagee going to court and getting a foreclosure judgment and then saying, oh, well, we got it before you did. Yeah, you have a security interest, but we win, and you lose, and that's not the law.
The complaint was your demand.
That's correct.
You said you wanted the rent. The tenant did not honor that demand.
That's
The tenant
correct.
did not pay the rent to you. The tenant was concerned about double liability to the existing owner and to the lender, and therefore the tenant paid into the registry of the court.
No, the tenant paid the association directly.
Pursuant to a court order that ordered the tenant to do that, because the association actually came into court and requested these rents to be paid to the association. It was granted.
Right.
The bank didn't do that.
We did. We did it after they did. But you can't beat a prior security interest by rushing to court first. And by the way, that order, the association went into court under the 720.3085, which is a homeowners statute, and they're not a homeowners association. They're a condominium association. And the condominium association statute has very extensive notice requirements before they can seek that relief. I understand they got the order, but they didn't even have entitlement to the order because it's kind of ironic that they're complaining that we didn't make a written demand when we did, and we served it on everyone, and they never made any written demand.
No. You didn't make a separate written demand so that you served a complaint that
Correct.
had that cause of action in it. But
Well, it also has a direct demand if you read the language in it. We demand that you pay the rents. We demand the owner, the tenant, the association pay all collective rents to the bank immediately. And going forward, all rents.
But conditions proceedings have to be satisfied before you file a
Agreed.
complaint.
It's not a condition proceeding.
Well, in Ginsburg, this court said it was.
Okay, may I address the Ginsburg case?
Yes, it
Because
says, it says, finally, a mortgagee's right to pursue foreclosure is subject to two conditions proceedings.
I understand.
One, the assignee must make a written demand for the rent, and two, the mortgagee must refuse to turn over the rent.
I'm ready to address that specific issue. I have both the House and the Senate analysis of this bill. They were both done at the same time, and if you look...
But we only look to the analysis if there's an ambiguity in the statute and we're asked to interpret it. This is a holding. It is a statement in this court's own opinion.
May I respond?
Yes.
Judge, the holding is based specifically on a quotation from the staff analysis. That's where it came from. If you look on the next page, it says, see House of Rep. Judiciary Committee bill analysis of the Senate. And the statute doesn't have that requirement in it.
You're saying that Ginsburg is wrong.
I'm saying that
You're saying it's wrong.
I'm saying it's wrong on that because it's not required by the statute.
It's not for you to say.
Well,
it's not for you to say. And it's not even for us to say.
Yeah, distinguish it then.
Because the opinion goes on to say, right after that, Lennar has failed to demonstrate a right to the rent under the statute because Lennar has not alleged a written demand for the rent as required by the statute. A written demand for the rent was absolutely necessary. Lennar must not now claim under the statute a possessory interest to those rents.
Correct. That was what that case was about. Actually, the case was about something a little bit different. In that case, Lennar had sued under conversion and civil theft and various theories that require a possessory and ownership interest to pursue, which they didn't have. And the reason they didn't have it is they had never made the demand at all. This judge, if the legislature had required that a pre-suit written demand be served so the person can not pay you and then you file the suit the next day, just like they did in the civil theft statute and the libel and slander statute and the medical malpractice statute, they could have easily required it, and they didn't. Because
you're saying, again, counsel, we will not think of overruling a decision of Judge Bartow about real estate.
Okay, Judge, may I distinguish it then?
How can you distinguish it?
I can easily distinguish it. Judge,
how can you distinguish?
I'll be happy to
distinguish the facts. You can't distinguish the language. The language is directly applicable.
Judge, I can distinguish it on this basis. The statute also says, unless otherwise agreed by the mortgagor and the mortgagee. And if you look at this opinion, I think it's in footnote 12. This assignment of rent, and the actual language of the assignment of rent is laid out in this particular opinion. This assignment of rent had contingencies related to providing the mortgagee a right to reinstate the loan and all that. Our loan documents do not, and as a matter of fact, our assignment of rent says this assignment of rent is effective immediately. There's no requirement of a declaration of default, and it falls within the
if the assignment is effective immediately, that means that they had to pay the rent to you, even if the mortgagor was not in default.
Okay,
that's ridiculous.
Well, let me tell you the next part of it.
The next part is not ridiculous, right?
I don't think the first part's ridiculous, but let me go to the second part.
Okay.
Judge, it says it's effective immediately. So when this thing was signed, Ocean Bank had an immediate right to the rent. It also says...
Even if they were not in default.
Yes, but, let me finish. We provided the notice of default, just like it's done in a lot of complaints. So really what we're talking about is, do we have to sit and wait for them to try to come in and refuse to pay? And our answer is, because this was a direct assignment effective immediately, that's not a requirement, and we fit in the statutory exception.
Unfortunately, the Ginsburg case is directly to the contrary of this position.
Just that the Ginsburg case even recognizes the statute says, unless otherwise agreed by the mortgagor and the mortgagee.
What is the otherwise agreement?
The otherwise agreement is
That it's effective immediately?
and
That doesn't mean that, for one thing, it can't mean that. It's got to mean that you give notice when there is a default. You didn't give, and Ginsburg says you got to do it, and you didn't.
we did, Judge. We did in the complaint, but
Okay, so then
can I tell you the second phrase in the assignment of rents?
Sure.
Notwithstanding the effective immediate assignment of the rents, that the owner of the property may continue to collect rents until he receives notice of default. So when we served the complaint and gave him notice of default, at that point, the owner no longer had the right to the rent.
What we're talking about only is the period between your filing, according to your contention, the filing of the foreclosure complaint and the final judgment of foreclosure, because you've got to be a merger.
There's no merger. Judge, merger doesn't eliminate the debt. It's just what it does, in effect, is it makes the judgment, the debt instrument in place of the...
Foreclose, the mortgage provided for, the rents would be security for the mortgage, correct? Security for the debt.
For the debt, not for the mortgage, yes.
But the promissory note and the mortgage merge into the final judgment upon its entry.
And the debt still exists until it's fully
It's
repaid.
as if the rents were a car. You had the property and you had a car.
Exactly.
The lien persists in the car. Here, the lien persists in the rent.
Exactly, and in fact, the assignment of rents actually says it follows through until the time of redemption expires.
You can't redeem it anymore, can you?
No, but that became an issue in the state.
If you got the rents, that effected a deduction to the extent of the rents from the amount due, didn't it?
Amount due for?
On the mortgage, on the note, on the debt.
If we get the rents, it will reduce the amount outstanding on our deficiency claim.
And so, what was the amount that was in the final judgment of foreclosure? Was it reduced by the rent or not?
No,
didn't you get a judgment for the entire amount unreduced by any rent?
Yes, because we don't have any rent. We don't have the rents to apply to the debt. When we get them, it will obviously liquidate the judgment in the amount of $18,200.
But they're still in the registry now.
They are with the association.
It's still with the association.
But they were paid to the association.
I have just one additional question. Would you address Article 13.4 of the Declaration? The Declaration was filed prior to this loan and the recording of the mortgage and all that. So would you address that?
Article 13.4 of the association, it's not an assignment of rents.
If the unit owner remains in possession of the unit and the claim of lien is foreclosed, the court in its discretion may require the unit owner to pay a reasonable rental for the unit.
Exactly. And what the rent statute says is an assignor may assign the rent to secure an indebtedness. At that point, there is no indebtedness. It can't be an assignment of rent. All it is a statement that the association can go into court if the unit owner remains in possession, which they weren't. The tenant was in possession, and the lien is foreclosed.
Well, that can't make any difference, can it?
Sure it can. Because this is to address an issue, there could easily be situations where someone...
But the unit owner, the tenant is paying rent to the owner of the condo.
Not if the unit owner is in possession, there wouldn't be any tenant. It's kind of a baffling statement, frankly, to put in your condominium document.
You issued the mortgage and the note pursuant to the declaration, which was filed prior to the...
Right, and the declaration says, at best, that if the unit owner is in possession, they can go get a court order for possession of the rent. But it doesn't say, nor does any statute, nor any case, nor anything else say, that they get possession and therefore somehow they jump ahead priority-wise over Ocean Bank's actual recorded assignment of
It
rent.
is recorded after the declaration.
Yes, but this is not an assignment of rents.
No, it's
This is not an assignment of the rents from the property. It's a statement that they have the right to go into court and try to make the unit owner pay rent when they're not paying their association fees, which I'm not sure what good that would do, frankly.
Well, because they're still having to maintain the property, and so they want those fees.
Right,
So
but
whoever's in possession of that unit, whether it's the owner or the tenant, they're trying to collect their association fees, and that's how they do it. They go to court and request it, and they're
And they can find that that's not what their clause says. Their clause says they can do it if the unit owner is in possession. It's very clear what it says. And by the way, they did not go into court under that section of the declaration. They went under the statute, which they didn't fulfill the requirements.
They went under 718 or 697?
They actually went in under 720, which doesn't even apply to them, but the
Homeowners
equivalent,
versus condo.
but the equivalent in the condominium requires written notice to both the tenant and to the owner, and there's nothing in the record that they ever gave that notice. I'm not sure, to be completely honest with you, why the county court issued that order, but we were a party to those proceedings. So they end up with a possessory right. It doesn't jump ahead of us. They have to have an actual recorded assignment of rents, which this is not under the statute, and they didn't proceed under it. We have priority, and I would just say, judges, lenders rely on these assignment of rents. This is not an uncommon thing. For an association to come in and pull out a clause in a document that's not an assignment of rents, or to go get an order to possession of the rents and then claim it's superior, lenders rely on their collateral when they do loan terms, when they decide to give the loans. It's like any other collateral.
The bankruptcy court is the one who keeps the closest eye on cash collateral orders and liens of this kind.
They are. And there are a lot of bankruptcy opinions, but there's nothing in Florida law, and I urge this court not to be the first to issue an opinion that says somehow if an association takes possession of a bank's rent collateral, it ends up with priority, because I don't believe that's the law. Thank you. I'd like to save 1 minute for rebuttal. I'll go on top of that.
Thank you.
May it please the court, my name is Jonathan Goldstein, and I'm here on behalf of the appellee, cross-appellant, 107th Avenue Office Park Condominium Association. The Condominium Association seeks reversal of the order which gave rent to the bank.
In part.
In part, that's
an
correct.
allocation less the maintenance fee.
Yes, exactly, Your Honor. And we seek reversal because Ocean Bank had no right to possession of any rent in the proceeding below. And the reason for that is a reason of enforcement. The issue is one of enforcement as opposed to priority. Ocean Bank did not enforce its right to rent pursuant to Florida Statute 697.07. 697.07 requires a written demand for rent.
Does the
In this
filing
case.
of the complaint satisfy that requirement?
I would say first, this court has stated no in the case of Ginsburg and MLB Properties versus Lennar Holdings. And that's Lennar Florida Holdings. And in that case, cited legislative history on the bill, went into depth on the analysis, and it dealt with the possessory rights of the plaintiff in that case.
What do you say to his argument that the decision precipitated a revision in the language of assignments of rent, namely that the rent would always be the property and collateral of the bank, and that permissive use was allowed until there was a written demand and nothing more?
An absolute assignment of rent is something antithetical to Florida law on assignment of rent. Florida's always been a lien theory state. And the notion that at the creation of an assignment of rent, that would be a transfer of ownership to the rent, which simply has never been accepted by Florida law. Instead, Florida law has...
security. It's got to be entirely security. It's not a transfer of title.
It is, and I will proceed with that point when I discuss merger as well. But for the sake of this point on assignments of rent, instead, the mortgagee can proceed under 69707, which was enacted because of this issue, to create a procedural framework, a comprehensive procedural framework to proceed on assignment of rents. And it asked for a written demand or an agreement as to the form of demand. And a statement that from the outset we have a transfer of rent is not a written demand for rent. This assignment of rent in this case does require notice of default, and they have conceded even with regard to notice of default that occurred in the complaint, not pre-suit. I will say that the notion that you can serve a written demand for rent after filing the complaint, by its very nature, if a written demand for rent is required by the statute to collect rent, and you file an action to enforce that right, and then serve the written demand after the filing, that is the paradigmatic case of an accrual of an action not occurring until after the action has been filed. If it's a condition precedent, that condition precedent has to occur before the action is filed, not after, in order for the cause of action to have accrued by the time of filing. And even if they put the demand in the complaint, it's not served until after the summons is issued by the court, after the complaint has been filed. And there's case law in a very similar context for arbitration notice that we've cited, where the court said that you can't prevail in this case because you didn't give pre-suit notice of a demand for arbitration and receive a refusal to arbitrate from the other side. I think that case is very analogous to this case. But Ginsburg is a case of this court, which deals with this very set of circumstances and explains the statute in depth. It's been cited by the 5th TCA as well. I think it controls this
Ginsburg
case.
seems to, at least how I read Ginsburg, is that although the statute authorizes the parties to determine what the priorities would be, that there are certain things you must do if you want to collect on the interim rent. And it says, pursuant to the statute, you have to file a written demand. And in the body it says, written demand by the mortgagee does not give title to the rent. Title only passes with possession, but merely gives the right to bring an action to foreclose on the lien upon refusal of the mortgagee to pay over the rent.
And this statutory policy, this statutory language promotes judicial economy and efficiency, because there's many cases where a pre-suit written demand for rent will resolve the issue of rent before court, in which case the labors of the court are not focused on a rent demand, which may a separate hearing before final adjudication and rent in the court registry. It's much more efficient if the parties work that out before court. If the court permits the written demand to be in the complaint, it could become common practice to simply forego the written demand for rent before the complaint, stick it in the complaint, and then this is an issue that's the court's problem, and not an issue that can be resolved amongst the parties. Now, similarly, the bank did not enforce its assignment of rent pending final adjudication. The statute is clear. It says pending final adjudication. It contemplates dispersal of the rent in the final judgment. Of course, it should be factored into the amount awarded in the final judgment, which did not occur here. And finally, there's the case of the merger doctrine, which is well settled. Whitehurst v. Camp, a Florida Supreme Court case, recently reaffirmed the merger doctrine, and in fact, it overcame the parties' rights to freedom of contract in that case, which is a very powerful concept. But despite freedom of contract over an interest rate, the court said no, because the mortgage merged into a final judgment, the statutory interest rate applied. And that's a powerful concept in the case of national merger.
If the mortgage merged, but then the assignment of rents merged.
And, Your Honor, I would take the position, we would take the position, the association, that the bundle, the assignment of rents is part and parcel to the bundle of property rights secured by the mortgage. And this goes back to Florida's reluctance to enforce absolute assignment of rents. It's a lien theory state. The rents are part, and to illustrate this, the very language...
Let me just ask you this. Did each of these foreclosure actions, were they filed in the same division or in separate divisions? Did they travel together, travel separately? What happened with these two proceedings? Because they were filed separately.
They were filed separately. The association doesn't name a first mortgagee because a first mortgagee is not in
They're filed in two entirely different divisions.
I would say they were filed both in the circuit court, but I would say I think they're different divisions. I can't say for sure unless I look at the association.
Let me ask you this, if the bank who filed their foreclosure action first, is that correct?
Yes.
And then the association subsequently filed their foreclosure action. If the bank had, prior to filing their own foreclosure action, had made a demand for rent, and it was refused by the tenant, would there be any way of you knowing or the association knowing when they filed their foreclosure action, or that judge knowing, that based upon the separate action, that there had already been a demand for the rent somewhere else? That's my concern, is since neither side has an obligation to notify the other, where does the communication?
The association is a party to this case. The association was a party to the complaint. Had a pre-suit demand for rent been made, the association, well, first, the association would be on notice when the bank seeks to adjudicate its right to the rent, if it makes a written demand. The bank would have to set a hearing to disperse the rent pending final adjudication.
The bank was not notified when you sought the payment of the rent in the association's foreclosure action.
The bank is not a proper party to the association's foreclosure. And again, if the bank had enforced its rights, the bank maybe could be heard to...
It definitely has a security interest in the rents, one way or another, doesn't it? And you went and claimed the rents and got the rents through an order without notifying the bank, who had a known security interest, which they were trying to foreclose on, and in a case in which you were a party defendant, correct?
The issue with the association's taking of the rents in the foreclosure case, to answer your question, Your Honor, there's two ways the association obtained rents. First, in the association case... How can
you claim the right and succeed in getting an assignment of the rents you know are have been given as security to another a lender which has previously sued you?
To focus on the association...
Without giving notice to them. This is not appropriate.
The association's foreclosure was brought pursuant to 718-116. Inherently in an association foreclosure, the association has the right to seek rent through the appointment of a receiver. Now, admittedly, the court did not appoint a receiver, but that order was never challenged in that case. I will say that the bank...
They have a right to seek rents, yes. They know that somebody else is claiming those same rents. They have been sued. You have been sued. And you don't give notice of the fact that you are taking those rents by an order of court?
The association was proceeding pursuant to...
Counsel, in all respects, there's no way to defend it. The question is, what are the legal consequences of it?
The bank, having not enforced its own assignment of rent, has not created a legal consequence for that. The bank...
How does that remove the lien from the rent stuff? That's the question that I don't think you've answered. Because that lien follows the rent.
The lien is only enforced if the bank sends a written demand, and this goes back to the issue of possession.
That's like saying the mortgage lien goes away until someone makes a demand. I just don't understand.
Associations take title to units that are mortgaged all the time. They take title in their foreclosure.
And they have to deal with that.
But the bank then foreclosed. In this case, the bank never foreclosed its assignment of rent. It never sent a written demand to them, and it never sought to enforce the written assignment of rent during the pendency of the foreclosure act.
Was in the bank's mortgage foreclosure case, was the assignment of rents attached? Was that foreclosed as well?
What was it referenced in the
What was the reference in the mortgage foreclosure action to the assignment of rents?
The mortgage foreclosure action, I believe, enclosed the assignment of rents as an exhibit and contained a count saying we want to foreclose the rent. And in its allegation that it sent written demand, the association denied that allegation specifically, and the bank had not sent a written demand. In addition, the bank never took any action to enforce that count.
It took an action. It filed a foreclosure case in which it didn't even have to, insofar as we're concerned, we're only concerned with the rents, it didn't even have to mention the foreclosure of the property. All it had to do was mention the right to security of the assignment of rents, which they did, and which you were on notice of.
In July,
I don't see, the upshot is there seems to be no effective way, or it's very argued, in which their existing security rights in the rents has been foreclosed. They were superior to you, and there's no lawful way in which that security right has been terminated.
and also inherently as an owner, because for a significant period of time during this process, the association was also an owner of the property. And that's why it's inherent in the ownership. Just to distinguish that from the period where the association got rents during its own foreclosure.
Wow.
But either way, you're correct, Your Honor, they didn't enforce the assignment of rent before the merger doctrine kicked in because,
you know, you took my question as a good one for you, and it was a bad one.
If I may add something on this issue of the bundle of rights regarding the assignment of rent. 69707 refers to mortgagees. The only party that enforces rent pursuant to 69707 is a mortgagee, which is, I think, a strong indicator that the assignment of rent right is part and parcel to the bundle of rights secured by the mortgage. After all, it's a mortgagee.
So suppose that the association took a bunch of personal property away from the condominium, things that were embraced by the security interest in the mortgage. Are you saying that under the merger doctrine, once the foreclosure occurs, all the personal property becomes the property of the association? Because the lien attached to it, and the lien follows the personal property wherever it goes, it follows rents wherever they go.
The bank had every opportunity for over a year to move to deal with the rent.
And you understand that your answer does not go to the substantive rights or the merits of who gets the rents, or in what order the rents are distributed. You are talking about they didn't do it the right way, correct? Procedurally.
Yes.
This is not an attractive argument, do you understand?
I would say
Your argument essentially is not that regarding the priority of the liens, it's whether or not they satisfy the condition preceding to collection of, or their entitlement to the interim rents under the circumstances.
I would argue that during the association's foreclosure, because of 718-116, the bank is on notice that an association inherently has an authority to seek rents through a receiver. Again, a receiver was not appointed. That order was not disturbed or reviewed or appealed by the owner, and the bank.
They weren't a party to your action.
I understand, Your
How
Honor.
did they have notice of it?
They would not have been put on notice because they were not a proper party. But again, this does go back to the issue of enforcement. The bank has not enforced its assignment of rent pre-final adjudication.
It looks to me like the bank is moving heaven and earth to enforce its right to priority. When does it terminate, in your view? Assume that I'll ask Mr. Nicholas.
If I may add one, should the court determine that the bank did follow the procedures in 69707,
or that it doesn't make any difference?
in the event that the court determines that, subsection 5 of 69707 gives the court significant discretion.
And that's where the association's entitlement to the maintenance fee amount seems pretty reasonable. To cut that out of it because that's insurance, taxes, maintenance.
The order, if the court declines to reverse because they cannot enforce, we request respectfully that they should not disturb the allocation by the...
How about the attorney's fees, though? Why should the attorney's fees get a senior lien?
I would say that the attorney's fees are secured by the association's lien as part of the maintenance. It's part of the rights the association has. It's similar to an obligation of the unit.
But by far the most important portion of the security.
a unit's obligation to pay property taxes prevents waste. Similarly, a unit's obligation to pay its obligations to the association prevents waste of the property. I think it is contemplated, and I don't think it's an abuse of discretion for the trial court to apportion the rents as it did. But again,
And in conclusion,
I will say, though, that the merger doctrine is completely applicable here. They did not enforce the assignment of rent. At the time they sought to enforce the assignment of rent, they were no longer a lender or a mortgagee. They were a judgment creditor. And accordingly, at that point in time, the rent, which was part and parcel to their rights under the mortgage, was foreclosed in the final judgment. The statutory language, pending final adjudication.
So what is the money in question? The order on appeal says that there will be a further distribution of rent shall be in accordance with this order. There's got to be a term in it. We don't even know that there are rents at the present time, do we?
I'm sorry, Your Honor.
There has to be an end, a termination of their entitlement to the rents.
The way the order, I would say the order contemplates that the bank will take title.
The foreclosure judgment was when, and this order distributing the funds or the rents, they're not, it's a fund, it's now in the possession of the association, was when, which came.
until the bank takes title.
Yeah, the bank would take title eventually, and then they would do what they want with the property, and they would take possession. Thank you.
They would be the landlord, that they would become the landlord.
They would have possession of the land.
Judge, the first answer is it's effectively ended because the rent, if there's a set amount of rents that have been collected.
It's all over.
Pardon me?
It's all over now.
It's over. We're just fighting over where the money goes. Second, to address your question, I believe it was, the association, after we served the rents demand in the lawsuit, after the list pendant saying that we were pursuing a route, the rents was filed and served on the association, went and filed a separate county court foreclosure action with no notice to Ocean Bank. It wasn't in the same division. It wasn't in circuit court. They left us out. They made no claim whatsoever for the rents in the case.
Okay.
So let's get down to the nitty-gritty.
I know you have a dead horse that you would love to.
No, I don't want to beat the dead horse. But as Sally Fine once told me, I want to make sure it's good and dead before I leave it there. Judge, to address the distribution, the court really didn't make that determination on what was needed to solely protect and preserve and maintain the property. That would not include attorney's fees. It would not include litigation costs. And what the association is trying to do is a backdoor effort. We have a statutory limitation where we pay them 1% of our mortgage. We want the rents paid over to us that we're entitled to, and we will pay that. But they're trying to increase that from about $1,500 to $16,800. That statute is limited on what the rents can be used to protect the mortgagor and the mortgagee, to physically protect the property, to pay taxes, to pay insurance, to make sure your collateral.
Just taking the month that the rent was payable and that you had the lien on it, cutting out the maintenance fee alone for the association is a pretty reasonable approximation of preservation and security.
It was
$300 attorney's fees and so on.
It would have been $357 per month.
Out of $1,800 and some, and that's a pretty fair approximation. Imagine a receiver's in possession. A receiver always has expenses of operating the property, utilities, and everything else. And that's what trial courts do, right? They cut a small amount out for operation.
Right, if the court can somehow find that issue is right for adjudication, since it hasn't really been considered by the trial court. What the trial court judge did was he looked at their judgment, that they had gone and gotten their separate litigation, and said, okay, well, I'm going to make you whole and give you everything. That was his comment. You can read the transcript.
That is a ruling on the substance of the priorities, which you say is wrong.
Well, thank you, Judge.
Thank you.
Thank you for your time.